This is ABC News legal analyst Royal Oakes welcoming you to Hinshaw and Culbertson's Insurance Law Program, where we discuss insurance and reinsurance issues of interest to industry professionals. Here's your host, the co-chair of Hinshaw's Global Insurance Services Practice Group, Scott Seaman.
Hello, everybody. We are pleased to announce the release of the second edition of our book entitled Duty to Defend, a 50-State Survey. This is volume number 3 of our On the Law series, which we proudly make available to our clients. The Duty to Defend 50-State Survey is the most popular volume by far in our series. First edition came out almost 6 years ago, and there have been several cases and developments with respect to the duty to defend during the past 6 years. So based on numerous requests, we thought it was an appropriate time to update the book. And as with our prior edition, the second edition includes an introduction that contains an overview of the duty to defend and the various issues commonly presented. The survey then goes state by state through all of the states. It's presented in a question and answer format and attempts to answer for each state questions that are significant for insurance claims professionals and lawyers that make decisions about properly responding to complaints presented to them for defense. So I thought I would just take a moment and go through the issues that we examine in the survey. First, we take a look at the standard for determining whether an insurer has a duty to defend. In most states, it's the four-corner rule, or in some states, they call the same rule the eight-corner test, and it's used by comparing the allegations of the complaint against the insurance policy language to see if there's a potential for coverage. The second issue we examine is under what circumstances, if any, will information that's not contained in the policy or the underlying complaint be considered in determining whether there's a duty to defend. And on this issue, there's considerable variance among the states as to whether and when extrinsic evidence may be used or must be used. The third issue we take a look at is, most of you know, the primary liability insurance contracts typically provide that the insurer will defend suits. In some policies, the term suit is defined. In other policies, suit is not a defined term. So an issue commonly presented is whether the duty to defend is limited to defending lawsuits, or whether the insurer is required to defend something other than a lawsuit, such as an administrative proceeding, an arbitration, or a demand letter. The fourth issue we look at is when the duty to defend begins. Depending upon the state and circumstances, the duty to defend may begin when a complaint is tendered to the insurer by the insured. It may just be notice of the complaint, or it may be something else. Fifth, we look at when the duty to defend ends. Once again, a lot of variance among the states, and depending upon the policy language and the circumstances, the duty to defend may terminate at different times. It may be upon exhaustion of limits by payment of the settlements or judgments. It may be dismissal of the entire action. It may be resolution of all potentially covered claims. In some states, the duty to defend continues through appeal. The sixth issue we examine is whether the insurer must defend a lawsuit if only some of the facts alleged or some of the counts included in the underlying complaint are potentially covered. This is commonly referred to as the mixed claim situation, and generally the answer is yes, the insurer must defend. Seventh, we examine under what circumstances an insured may select its own defense counsel to be paid by the insurer. In other words, under what circumstances, if any, is an insured entitled to independent counsel. The eighth issue that we look at is when an insurer pays for the defense of a matter where only some of the claims alleged in the underlying complaint are potentially covered, whether that insurer may seek to recoup from the insured the costs that are applicable to claims that are not covered. This is generally referred to as the right of recoupment, and states across the country are divided on this issue. Ninth, we look at whether pre-tender costs are covered. Issue number 10 is the examination of the consequences for breaching the duty to defend and that varies considerably from state to state. And finally, we look at whether an insured that prevails in coverage litigation may recover from the insurer the attorney's fees and cost expended for litigating coverage, the so-called cost shifting issue. So any survey or overview is only a research tool. You all know that for any case or claim, consideration of which state's law applies, research of the applicable law, review of the relevant pleadings, facts, and circumstances, and review of the insurance contract language are required. This publication, Duty to Defend a 50-State Survey, was prepared by attorneys in the Global Insurance Services Practice Group at Hinshaw Culbertson, and we appreciate the efforts of all the people who helped prepare this book. Please feel free to contact me or your regular contact at the firm for more information. To obtain your copy of the ebook, click on the attached link or go to www.hinshawlaw.com. Click on the Insurance and Reinsurance Services page and go to the Insights tab. When you get there, click on the book cover and provide some of the contact information we request, and you will be given access to the survey. While many claims professionals and executives and lawyers have found the first edition of the survey to be a valuable resource, we hope that you will find the second edition to be a useful resource as well. Thank you.
You've been listening to Hinshaw Culbertson LLP's Insurance Law Radio. The information contained in this program is provided solely for general informational purposes and does not constitute legal advice. For information on past and upcoming Insurance Law Radio programs, visit the Insurance Services Practice Group page of www.hinshawlaw.com. This is Royal Oaks thanking you for joining us and inviting you to join us for the next episode of Insurance Law Radio.